in the room. Great. Perfect to see that. So I think, Charlotte, we can start, huh? So if there are some people joining us a bit later, I mean, it's anyway first the introduction of the chapters, so that we have still some minutes until the real content is starting. So then welcome again from my side. Charlotte, thank you again for the introduction and for coordinating the entire meeting here and helping me in the background. And also a warm welcome to Sue and to Daniel. You will have your introduction just in a minute. And I will just start with some information about our slide, about our chapter. You see that our meeting today considers the responsible contracting. So we have two experts here who will tell you how to implement human rights due diligence obligations in your contracts in your company in responsibility aligned with your suppliers. Yeah, and actually we are having some general information. This is a meeting, it's not a webinar, so we want to have you active there. As Charlotte already mentioned, please feel free to tell your question, to share your links in the chat that you are already using. I see that we have already 8 comments there. Just be active there, share your thoughts. We are happy if you're joining us there. Mute your phone. This would be or switch on your camera if you want, but also mute your phone if you want, because otherwise it will be disturbing in the background if we have any noise. Use the chat window as we already mentioned, and as Charlotte already said, we are recording this meeting, so you can access it later on SPP. You can share it with your peers, you can share it within your company with all your contacts that you're having, so that they also get the content, and I think this is very valuable. So we have still people joining here. Welcome, welcome. Just some information on SPP, Sustainable Procurement Pledge. It's a big organization. We have already more than 20,000 followers on LinkedIn. I saw that's really amazing, Charlotte. It was really a big step forward. The last number I had in mind was 40,000, so 14,000, and now it's already more than 20,000. So really great. Actually, the goal is that we achieve 1 million procurement professionals who commit to the Sustainable Procurement Pledge. And we want that a 3/4 of this, so 75%, really confirm also that they make more sustainable sourcing decisions because of the SPP engagement. And the vision is that all supply chains globally, that they all embedded sustainable procurement practices by 2030. It's really ambitious. Let's see if we can make it, but I think we are on a good way with such content like we provide for you today. Our strategy is to encourage leadership, of course, so that you can also share your knowledge with your teams and with your peers, with your network. And we want to empower you and equip you with the necessary know-how and the necessary tools that you should know that will help you to make this happen. Yeah, how do we do this? Actually, we focus on closing the gaps. We defined 4 gaps, actually the knowledge gap. We see that quite many people often don't know how to start, where to find the right information. So this is what we want to do with these SPP ambassadors, that we help each other, that we show where are best practice cases and how can sustainable procurement look like. We support also, we have this support gap, so we also show you which tools you can use and which solutions can help you. We also share here and there some providers with their sustainability solutions. We help you also to collaborate with the right peers so that you get more self-confident, that you really know, yeah, that's the right way I'm really doing it in the right matter, I'm focusing on the right topics. So to help you also there to be more confident on this. And of course, as we already said, we want to support the leadership in sustainability so that you're really great leaders and ready to support others. About the chapter, we had 3 people who are kind of chair of this chapter. So it's Simon who started this together with Francesco. I'm joining this also since last year. And we are trying to find the right topics for you in travel and hospitality. That's our main focus. And we are really happy if you also let us know what topics are interesting for you, what you're looking for, so that we can help you. We want really to accelerate the sustainable development across the travel and hospitality industry. And for this, we defined our primary focus areas. So one point is the net zero greenhouse gas emissions, the other one is waste reduction, and the third one is social elevation or combating slavery. So this is actually quite close to the topic that we are talking today, the social dimension with human rights, where we have our speakers today. And actually everything depends on your collaboration also with us. So we are happy if you support our chapter, help us to promote it, spread the word, share your ideas, your needs that you're having, maybe your connections, your partners that can bring in valuable input, so that we can grow with our chapter, that we can reach more people, and that we have an amazing impact on sustainable development. And of course, you can join our chapter. You can become an SPP ambassador if you're not already. And you can pledge on in the official site or on LinkedIn. You can join our Travel and Hospitality chapter on LinkedIn, follow it, and also contribute to the community with your posts, with your tools that you want to share, or your best practices that you want to share. So just a link to our group here. And I hope that this group will grow in the future and that we have many, many more webinars to come. And that's actually already the part where I hand over to our speakers today. Welcome again to Daniel and Sue. I'm very, very happy that you are taking the time for helping us today and bring us some more information and show us how we can implement human rights due diligence together with the suppliers in our contracts. It's a very important topic. I think many people underestimate this, and I see when I talk to procurement professionals that very often they still just concentrate on code of conducts, where they shift all the responsibilities to their suppliers. And we have to say that this is not enough if you want to be a responsible procurement organization. And therefore, I'm very happy that you share your insight and your expertise with us in our chapter. And feel free now to start. I wish you all the best, and please take also your time to introduce yourself again.
Great. Sue, you want to go first with introductions?
Sure. I'm Susan Maslow. I have been a business lawyer for over 40 years now. I am also chair of the Corporate Social Responsibility Law Committee of the American Bar Association's Business Law Section, and I was vice chair and continue to be vice chair of the working group that drafted the model contract clauses. Daniel, that's...
I'm sorry. From Germany, German lawyer specialized on business and human rights and the German Supply Chain Act. I'm mainly working in-house implementing the German Supply Chain Act, especially on preventive and remedial measures. And two important parts of those are contracts and purchasing practices. And part-time, I support RCP as our European legal advisor. And very happy to be doing this today with all of you and with Sue, an honor, because Sue and the ABA really are the pioneers, but Sue will tell you more about that. Like, this is all coming from the ABA, from this ABA working group that Sue has been heading. And so, yeah, great to be sharing this stage with you. I would suggest you start and with the contracting, and then I go over to what this means in the world of mandatory human rights due diligence. Great, and I will be sharing some links in the chat on all of what we are saying, so that you can look it up after. But having to hand it over to Sue now.
Thank you, Daniel. So a brief introduction into the responsible contracting project. Next slide, Daniel. David Snyder, who is actually chair of the working group that Daniel mentioned, that drafted the model contract clauses, likes to say that the project was born of frustration and hope. Frustration because so many companies, some with great sincerity and some not so much, posted the Universal Declaration of Human Rights or the OECD guiding principles or the OECD guidance or guidelines on their websites, but failed to operationalize those lofty goals in their operations. The initial hurdle of the working group was the fact that commercial law does not address human rights violations. a soccer ball that's black and white and bounces the way it's supposed to and is stitched beautifully by a child laborer does not look or appear to be a defective or a non-conforming good. So the first thing that we did in MCC's version 1, which came out in 2018, was to include in the very definition of defective goods the idea of any taint that came from forced or child labor. We received a lot of great feedback, as we had hoped, in after publishing version 1.0. And the gist of it was the fact that we had failed to recognize the role that buyer conduct played in the problems that arise in the supply chain. And perhaps as importantly, the fact that buyers were inclined to use the representation and warranty structure for their own plausible deniability about what was really happening in their own supply chains. So the MCCs 2.0, which came out in 2021, are the first attempt to Google translate the UNGPs and the OECD due diligence guidance into a contract. RCP, or the Responsible Contracting Project, out of Rutgers Law School, which is under the leadership of Sarah Dadouche, is a spin-off of the business law section working group and is tasked with uptake and implementation of new tools. The idea was to develop 4 work streams to provide services to businesses and consultancies, investors, governmental agencies, CSOs or NGOs, organized on a local, national, or international level, and benchmarking organizations. Next slide. Okay. The rather revolutionary idea in 2021, when the working group first got started, was the idea that contracts can matter for human rights. Contracts are the legal links that could tie the supply chain together with the sometimes complex, multi-tiered structure that a supply chain often represents. The contracts are the agreed upon law between the parties. Business partners have used contracts for centuries to be clear about their respective expectations and enforceable obligations. Contracts can transform policies into operational requirements, just like the specs with respect to the raw materials you use, the weight, height, mobility, etc., of the required good. Contracts can make soft policies binding throughout the supply chain with very clear contractual terms. There can be no sincere disagreement about what the violation or adverse human rights or environmental impact might be, or what even constitutes characteristics of modern slavery. For instance, indentured debt. If we're not clear that indentured debt is an aspect of modern slavery, there can be confusion and lack of follow-through by a supplier. A child that is 14 years old and is working in a mine is, depending on how you look at it, either a very young worker who has a limited education for a variety of different reasons, or a victim of child labor. So the contract can be used to narrow this disagreement as to some very, very basic terms. And it can help the parties develop more transparent and trusting relationships, especially in countries where there is no applicable law. They can avoid the disconnect between the standard of conduct and actual conduct, and can include collection and reporting requirements for data that are needed as critical tools for implementing human rights and environmental due diligence. Contract terms can assist in avoiding customs and border protection enforcement and withhold release orders here in the US, and can help address growing investor and stakeholder interest in ESG factors. They can certainly help in avoiding litigation and reputational risk. And that's even before we get to the growing development of applicable law, which Daniel will cover. But contracting, as usual, doesn't work. Next slide, Daniel, please. Too many contracts are misused in managing human rights and environmental risks. Ever since a handshake no longer was sufficient to seal the deal, contracts have been designed to manage company risk, not human rights risks. Traditional contracting reflects the obligation adverse focus of both the parties with negotiated risk shifting. Who's going to do what, and when are they going to do it, and what happens if the obligated party fails to do so. Risk shifting is not the same thing as risk management, however, and risk shifting is not historically effective for company risk management in the context of human rights impacts. Contracting as usual, as we say, doesn't work. Traditional contracts, if they address human rights violations at all, rely on one-sided supplier representations and warranties with respect to compliance with the buyer-imposed policies or stated policies, which is called the tick box approach. Do you have any child labor in your supply chain? Absolutely not. Do you have any, forced labor or indentured debt in your supply chain? Absolutely not. So the tick box approach we found is both unrealistic and dangerous. It's unrealistic because even if the representation is true at the moment that the contract is signed, everyone knows that human rights and environmental risks are not static. And there are ever evolving situations during the course of performance or operations which equal a potential for a human rights or environmental adverse impact. And it's dangerous because the reps and warranty structure discourages the sharing of discovered problems. If the problem is not reported and addressed, the problem can grow in scope, scale, and severity. And traditional contracts ignore the buyer's responsibility to avoid contributing to the human rights or environmental risk by way of the buyer purchasing practice with a constant buyer search for the lowest possible price, for the shortest lead time, for delivery, for flexibility in the ability to make last-minute changes or design or quality, and cost shifting without any assistance. In other words, the buyer's insistence on gold standards in manufacturing and not even bronze pricing to the manufacturer has caused so many of the problems that arise in the supply chain. An additional characteristic of traditional contracting is the prioritizing of traditional remedies between the parties in the form of the non-breaching parties' damages over remediation for a victim. The people actually harmed by a breach of a human rights or environmental adverse impact are left behind. But in the last decade, things have changed. While efforts to reflect what we call soft law policies in traditional contracting has proven to be not effective, effectiveness is now a legal requirement. So it's not just a nice thing to have, a marketing message without results. Human rights and environmental due diligence is now a must-have. Before adoption of a human rights or environmental policy, any testing of that effectiveness was voluntary, but it's becoming mandatory with the international development of new human rights and environmental due diligence laws and trade bans. Clearly, human rights and environmental violations are bad for business. Companies need a new approach rooted in shared responsibility, as indicated in the UNGPs and the OECD guidelines and guidance. Contract clauses requiring an operational level grievance mechanism, audits and certifications as components, as preventative parts of a robust assortment of contract terms to address human rights and environmental due diligence, play an important role in monitoring measures and success in operationalizing policies and legal requirements. The Responsible Contracting Project has formulated 3 R's of responsible contracting. The first being the responsible allocation of risk and obligations, again, as comparison to risk shifting to the supplier. The second being responsible purchasing practices that enable effective human rights and environmental due diligence and build trust and support the supplier's human rights and environmental performance. And prioritizing remediation over traditional remedies like the suspension of payment, termination, and damages that flow to the non-breaching party, which was usually the buyer, with termination as a last resort and a requirement for a responsible exit rather than a cut and run policy, leaving the human rights or environmental mess behind for someone else to address, if ever. So a snapshot comparing conventional contracts with human rights and environmental due diligence aligned contracts is before you. We've touched upon these, the conventional contract having static supplier only promises of perfect compliance, which is always the goal, but simply not the reality, at least in the 21st century as I know it. Having a supplier solely responsible for the human rights, which is impossible when the buyer is imposing impossible terms, and discouraging the sharing of discovered problems, as I mentioned, or efforts to remediate with remedies for social breach flowing from the supplier to the buyer, and neither party having any specific obligation to provide a remedy to the victims. Again, looking at the human rights and environmental due diligence aligned contracts, the MCCs, you'll see a joint obligation, you'll see shared responsibility, with buyer committing to responsible purchasing practices. You'll see a operational level grievance mechanism where both buyer and supplier have to engage stakeholder input into the process, and remediation to make the victims whole before or in conjunction with traditional contract remedies. A breakdown of the clauses that you can find in the supplier model contract clauses, which are part of the tool set that you'll find on the Responsible Contracting Project website that we've provided, are as follows. Definitions, because we're lawyers and we can't deal without definitions, and also because really, as I mentioned when I started, there was some sincere disagreement or disconnect between terms used: buyer's obligations, supplier obligations, and details as to what has to happen upon discovery of an adverse impact and how to formulate a corrective action plan. We also have in Article 6 a process where the corrective action plan fails to be implemented, and there is ultimately a decision that there's been a true default or breach on the part of one party or the other, and a process to figure out what to do in the event of such a default. Again, looking at first a corrective action plan, and then a clear statement that there is no benefit from the default or breach to run to the parties to the contract, with a dispute resolution process, with intercompany dialogue to quickly address disputes, because litigation, which lasts for 2, 3, 4, 5, 6 years, again, does nothing to assist those that have been harmed, and a responsible exit, again, to be sure that we don't leave behind a adverse human rights or environmental impact. Daniel thought it would be a good idea, and I do as well, to give you some sense of the context and experience we've had in implementing the model contract clauses or the supplier contract clauses, both which you'll find on the website. And I can say that we've had a variety of different industries and companies that have adopted the MCCs in whole or in part. We have created them in such a way that they are modular. It is not you've got to take all of them as we've written them, or else they won't work at all. We certainly have a preference for full adoption for maximum effectivity, but everybody's at a different place in terms of their journey with respect to human rights and environmental due diligence and even commitment. I will tell you that the biggest hurdles that we have encountered have been very industry specific. For example, in the shipping industry, we got a tremendous amount of pushback and refusal to have unannounced audits. The concept that we were confronted with is that in the shipping industry, for security reasons, they insist upon permission to enter the sites, and that unannounced audits wouldn't work in that context. A similar pushback that's been somewhat universal in terms of industries would be pricing, a fair or living wage pricing. Some of that is sort of the suggestion that such an idea is anti-capitalistic, or a failure to maintain the shareholder primacy and profit maximization needs of the company, but without any kind of address to a pricing, the lowest possible price. We really can't expect too much in the way of solving human rights or environmental problem within supply chains. And also some, again, in the US in particular, some suggestion that buyer cooperation, when they've used the same supplier chain, it can be antitrust and lead to an antitrust violation. And then, of course, in the US, as everybody knows, political pushback, which is on a state-by-state basis. And on that, I will turn it over to Daniel to give you some more specifics as to evolving law and the need to look at these clauses with a real commitment.
Great, thank you. So as Sue has mentioned, in the new world of mandatory human rights due diligence, with laws coming in from France, Germany, the EU, and well, soon all EU member states and even other countries, the need for effective due diligence is ever greater. I mean, Sue mentioned it also in a non-HREDD context. It is beneficial to have effective human rights due diligence, although you could like have a long discussion in economic terms, like reputational benefits, also disruption prevention, maybe higher costs. So it's a hard discussion you can have for a long time. It was still a good idea to do it, but now it becomes from a must-have. It's turning from a nice-to-have into a must-have, at least in Europe. But as you know, the CSDDD scope is not applied only to companies based in Europe, but also companies operating in the world's largest internal market, the European Union, above a certain threshold. So this will be something that firms from all over the world will need to look at. What's the main points? Basically, both the German Supply Chain Act and the CSDDD mention that companies should, as part of their preventive measures, as part of their human rights due diligence, look at contracts and look at responsible purchasing practices. They should design both in a way that make human rights risks less likely to materialize. This is essentially what the requirement is under those laws. You could now think about, okay, how is it in Norway or how is it in France? They don't say anything about contracts or responsible purchasing. They just say you have to do effective human rights due diligence in your supply chains. Well, we believe that any company trying to do that will always have to look also at their contracts and at their purchasing practices. Why I'm saying this? I'm saying this because this means that this is relevant not only if you're operating in a in Germany, or in the future under the CSDDD, but also now in France and in Norway under these under the transparency law and the vigilance law. So preventive measures have to be effective. That means they have to be reasonably likely to work, and companies need to address their own potential contributions to adverse impacts. And well, as Sue has said, the costs, the prices set, and how they reflect costs, and the incentives that the buyer sets via his behavior, be it via contracts, be it via purchasing practice, selection criteria, and so on, are of course a contribution to a behavior of the supplier. And if the supplier, if this contribution, if this incentives is set in a way that makes worse human rights outcomes less more likely, or at least not contributes to making good human rights outcomes more likely, then it's not effective. So these are legal requirements now, directly from the law. In this context, in the links that that I posted in the chat, there are several useful, I believe. We have a short summary on all of this in a blog post, in a podcast, and most crucially, there's guidance by BAFA and the help desk. BAFA is the German authority in charge of implementing this law, implementing the German Supply Chain Act. And they say very similar things. I posted the English link in the chat, so that's useful to take a look at. But what are now the requirements on contracts? Well, first, contracts must be reasonable, fair, and non-discriminatory in the German and in the European context. This is specified in the contract law of Germany, and this is also specified in the CSDDD in relation to SMEs. This means that you should only only require realistic obligations. You should not require, for example, what Sue mentioned, obligations that guarantee, okay, no child labor in the supply chain, no forced labor in the supply chain, just like that, because it's not realistic. Because risks, human rights risks, human rights violations are prevalent in many supply chains, in many operations of many companies. And also, if you look at Germany, you don't have to go that far. You don't have to look at, I don't know, Congo and cobalt to find human rights problems. You can start in the US or in Germany. I mean, in Germany, we had a big problem last year in logistics that was showing that truckers are basically often exploited like slaves in Germany, in conditions very similar to forced labor. Similar things are happening in construction or in agriculture in Germany. And even in very like normal, let's say, office firms, often gender equality from the gender pay gap, the pay gap between women and men is still not closed. And this is a human right as well. So, and in the US, I don't want to begin about the US because there's many human rights problems there on unions and child labor. Well, but that's for another conversation. So no firm can realistically say its own operations are free from risks and violations, and less realistically say its supply chain is free from risks and violations. So this is not a fair term to put in a contract, and it will incentivize, and here the effectiveness requirements comes in, as Sue also mentioned, will incentivize that the supplier will want to hide problems. And this is a big problem because corporate practice in Germany, at least now, relies on asking suppliers questionnaires, sending audits, talking with suppliers. Well, we have the impression that typical risks in your industry are this, how do you address them? Suppliers are not likely to talk openly about this if they have signed a contract that says, if there's a risk or a violation, I have to pay a fine or I will be fired. Yeah, my contract will be terminated. So this is a real problem for establishing effective human rights due diligence, and creates therefore liability risks. Yeah, it becomes a risk for the company to not manage this properly. There's also very interesting details on purchasing practices in the European Supply Chain Act and in the German Supply Chain Act. The basic message is you have to look at the incentives you set via prices, contract lengths, via also things like delivery times. Are you setting these incentives, these conditions, these commercial conditions in a way that enable your supplier to work without creating human rights risks? That's essentially the obligation that firms now have in Germany and soon in all of Europe. So this means looking at the price. Is the price sufficient to cover sustainability costs? This also means many other details, essentially not only focusing on price and quality, for example, when selecting suppliers. Yeah, also look at sustainability performance. Don't just say the cheapest one wins, but let's say the one that has the best offer on price, quality, and sustainability. Yeah, weigh them all in supplier selection. These kinds of requirements follow. And companies should also include the requirement, this requirement, in their contracts, we believe. Why is that the case? They should oblige themselves against their supplier that they will commit to responsible purchasing, that they will look and address their incentives, the incentives that they set. Why put it in the contract? There's two basic reasons. One is it's very fair. I mean, you in your supplier code of conduct oblige the supplier to a whole lot of things, yeah, whole lot of human rights, environmental obligations. So to signal to him that he's not alone and that you are also responsible and that you will work together to create an atmosphere of collaboration on all these issues, you should also state your own responsibilities. If you want something from the supplier, you should also tell him what you are doing to help him. But more crucially, if you don't put it in there, this is likely to create a legal reality that is kind of very much deriving from the socio-economic reality. Because in the socio-economic reality, the buyer's behavior has relevance for the supplier's capacity to uphold human rights. If you pay very low prices, the supplier cannot pay his workers a living wage. If you create a new legal reality that is not connected to the socio-economic reality and say, okay, only the supplier, well, we ignore the role of the purchasing practices by the buyer. What happens? The supplier is not likely to address these problems, because if he says, there's a problem because of your purchasing practices, the buyer will say, oh, you say there's a problem. Actually, when I look at my contract, it says you have to look at all these human rights and environmental risks. That's another to-do for you, sorry. See you next time. So this is kind of the incentive against effective collaboration, which is required by the law, which is why you should put it in your contracts as well. To give them also the security that you are their partner in doing all this. Another very crucial point addressed also by the German and the European law is responsible exit. Termination of contracts has an important role to play in human rights due diligence, because if you don't say we will never if you say we will never terminate, if you don't have a termination option, the supplier will think, okay, this is not a real issue for the buyer. Yeah, that's not important for them. So it's important to have termination rights, but it's very important to get them right. I saw in my practice termination rights that said, like, if there's a risk or a violation, you can immediately terminate. This is horrible, because this strengthens the incentive to hide problems so very much that the supplier will basically try to build just a fake reality where he's like, okay, yeah, if I get a questionnaire, I will always say, yes, everything is super fine. If we have to do audits, I will really hard, I will try to get an auditor that is very, very nice to me, maybe engage in corruption, these kinds of things. So it sets very perverse incentives, and it doesn't help for human rights, because the problem is termination, if you do terminate, also creates human rights risks. If you terminate in a case of child labor or in a case of forced labor, indicators that are present. It can be that the person being exploited after your termination will be exploited even more, because maybe he loses this job and will go to have another job where he's exploited more because they are in this exploitation for an economic need. Or a new buyer comes in, let's say from a Chinese or Russian country, and they don't really care about what their supplier is doing in human rights. So the situation is not getting better for them. But your human rights due diligence always needs to be about making the situation better for the people actually affected. So what should you do? You should first, because termination is not is problematic in a human rights view, restrict it to situations of last resort. Yes, termination has to be on the menu, but it should be the end of a long escalation process in which you give the supplier the chance to do better and tell him how he has to do better. There can be exceptions of this, zero tolerance exceptions, which is also a very complex topic, because if you do define too many zero tolerance incidents, too wide ranging, yeah, you have the problem that you again set the wrong incentives with your termination rights. But there might be situations, for example, if a supplier in his behavior shows that he doesn't care about this at all, and even consciously violates these things. Like, for example, there have been cases in Germany, of employers sending paramilitary units to break up strikes. If you do something like this, well, it's clear this supplier, we cannot work with him in terms of human rights. Yeah, so there's room for for zero tolerance, but it should be treated very carefully. Some even say, let's not do zero tolerance at all. It's a complex conversation. But if you do terminate, you should evaluate the impact you are creating with this termination, and if possible, address it. So address human rights adverse impacts that you are creating with your termination to right to work, to right to decent incomes. Do not ignore this impact. Otherwise, you're contributing to human rights risks and violations. So similarly to what Sue said, this is a bit based on the experience of implementing all of these requirements with companies. Because companies here in Europe, companies are, we are working with several companies as RCP, yeah, doing gap analysis of their contracts, of the supplier code of conducts, and helping them to better implement, align their contracts with human rights due diligence. The problem is our requirements are, of course, complex. Yeah, it's not like, okay, let's just put these requirements in all of our contracts, and for example, let's put price escalation clauses in all of our contracts. This is not realistically feasible. And that is, in our view, also not required. What you have to do in human rights due diligence is always prioritize and continuously improve. What does it mean for the case of responsible contracting and responsible purchasing? Go a bit hand in hand always. You should know the risk in your supply chain. Know which categories of your spend, spend categories and supply chains are high risk, and which are not. You should, for all of your spend categories, of all suppliers of all of your spend categories, implement the general messages. Yes, human rights due diligence. It's something that both parties have to do, not only the supplier. And yes, the buyer will be obliged to responsible purchasing. But now the question, in complex supply chains, this is not enough. For example, for a textile supplier, or for a trucking supplier also, where it's very, very typical that the wages are super low, and that the prices are also often very low, that the buyer pays to the supplier. Agriculture is another example, or cleaning, for example. Here it is useful to put more in your contracts. Put, for example, concrete price escalation clause. If the labor costs rise, the price will rise. This is very sensible. Or put more detailed principles on pricing. Yeah? More detailed obligations on the pricing of the supplier. In this way, like with this two, like thinking about these two levels, basic for all, advanced for high risk, it is feasible to implement this. But it does require you to really understand also the risks and think about the risks that your own purchasing practices can create. Not only about the risks that your suppliers have. It's very usual to look at, oh, this supplier had these risks, this supplier has these. No, look at the typical risks in the products that you sell, that you buy. Sorry, in the products that you buy. Put them next to the spend categories. Let's see which are the highest risk categories and that have the comparatively highest spend. And then start focusing on those. The ones where you have a lot of spend and a high risk. And this is where you should proactively do responsible purchasing and contracting with these kinds of detailed clauses. Yeah, with the detailed pricing clauses. So that's it from me at this point. Oh yeah, one last slide, because also to the question, but we also want to give you some time for questions. Because there was already one question. So we have a lot of model contract clauses in the toolkit link that I sent around. So maybe one can be overwhelmed. Oh my God, so many model contract clauses. Which are the right ones for me? So we have the ABA model contract clauses 2.0. Kind of the mother of all of these other clauses, because they inspired all of the other clauses. They are tailored if you're operating in the US. Yeah, if you're a US firm, have a lot of US business, that's the ones that you should look at. We have a responsible purchaser code of conduct. Also linked to that is designed to contain the obligations on responsible purchasing that a buyer should commit to. That's relevant in any context. We have the SMCs that are tailored for the textile industry and have been developed in collaboration with suppliers and with GIZ and STTI. And we have the European model contract clauses, which are currently being developed, also based on the MCCs 2.0. But we looked at, if you say, okay, how did the MCCs 2.0 come up? They put the MCCs 1.0 next to UNGP's OECD guidance and created the MCCs 2.0. Now, what are we doing in the European working group? We put the MCCs 2.0 next to the CSDDD and create the EMCs. There's already a first version, which is not yet a zero draft, but more like a consultation draft online now. Okay, I would say let's focus, let's go to questions now. We have some in the chat. Maybe we take them from the chat at first, and then we can see if anyone has more questions that they want to say in person.
Maybe I just share just some more hints from our side before we enter to the Q&A session, because then we would stop the recording so that everybody is more free and more, maybe not so shy to ask the questions. Yeah, and I don't know if you have some minutes left afterwards, after 4 o'clock, so that we can maybe even stay a bit longer, those who can. But just let me show you some more hints. Wait. So that's how it is. Wait. Oh, I can't enter this here.
Right.
So I have so many pictures here. My goodness, so many I can. Yeah, I just wanted to give some advice for some actions that all the participants can do today. Yeah, first of all, of course, join SPP community in case you're not an ambassador. So just start to be so. We have a special sustainable procurement pledge page where you can enter, where you can register so that you're always up to date. We already mentioned that you should become a member of our SPP Travel and Hospitality group. Yeah, you have this group also on LinkedIn where you can ask for joining us, and we will activate that, not a problem. You can follow our YouTube playlist where we will also find this recording of this session here, of this meeting here afterwards. So we will put it there. We already mentioned, and I saw it also in the chat from the colleagues from the latest SPP chapter on human rights, that there will be another webinar also next week, and there's this separate chapter which just started. So you also find these two links here. So this is just what I wanted to give you on the way. so that you know where to proceed and where you can join us and where you can be active. And yeah, that's from my side. So I think we can stop the recording and then we can start with the Q&As. But you also see Daniel and Sue from the session. Maybe you want